Amicus Curiae submits that the trial chamber erred in law when finding Krajišnik guilty of forcible transfer as other inhuman acts, without finding that the displacements were of sufficient gravity to constitute other inhuman acts. The appeal chamber finds that the trial chamber indeed erroneously failed to find that the instances of forcible transfer were sufficiently serious to amount to other inhuman acts under Article 5I of the statute. This error does not, however, invalidate the judgment, as the acts of forcible transfer were of similar seriousness to the instances of deportation. Thus, this ground of appeal is dismissed. Amicus Curiae further submits that the trial chamber erred in fact when making findings with respect to Krajišnik's hierarchical positions in the Bosnian Serb leadership. The appeal chamber is satisfied, however, that the trial chamber exercised caution in assessing the relevant witness evidence, and it is not convinced that the additional evidence provided by Radovan Karadzic is sufficient to undermine the extensive evidence supporting the trial chamber's findings. Amicus Curiae further argues that the trial chamber's findings regarding Krajišnik's powers and authority are at odds with his conclusion that he lacked effective control. The appeal chamber disagrees, as the trial chamber correctly held that effective control is not a required element of JCE liability, the only form of responsibility found applicable to Krajišnik. Next, Amicus Curiae submits that the prosecution breached Rule 90H I to the rules when it failed to put to Krajišnik during his testimony material matters on which it relied to prove his guilt and which were in contradiction with his evidence. The appeal chamber finds, however, that Rule 90H I of the rules was not intended to apply to an accused testifying as a witness in his own case. Furthermore, the appeal chamber is satisfied that Krajišnik was well aware of the prosecution's case against him. Thus, this ground of appeal is dismissed. Amicus Curiae further alleges that the trial chamber erroneously applied the law on cumulative convictions and requests the appeal chamber to quash the convictions on count 3, persecution, or alternatively on count 5, murder, count 7, deportation, and count 8, inhuman acts. The appeal chamber recalls, however, that the tribunal's jurisprudence on intra-Article 5 cumulative convictions is well established. Therefore, the appeal chamber, by majority, Judge Gurney dissenting, finds that the trial chamber did not err in cumulating the convictions for persecution with the conviction for other crimes against humanity based on the same facts. This ground of appeal is dismissed. I will now turn to Momčilo Krajišnik's appeal. In relation to Krajišnik's submissions that the trial chamber violated his fair trial rights, the appeal chamber recalls that some of these arguments were already dismissed under the grounds of appeal submitted by Amicus Curiae. Similarly, Krajišnik does not show any error by the trial chamber in relation to the remainder of his submissions. Krajišnik further argues that the trial chamber erred in law and in fact in finding that he was a JCE member, as he and the other alleged members of the JCE were simply individuals carrying out tasks within their lawful competencies as part of the functioning of the state administration and in accordance with the Constitution. The appeal chamber dismisses his arguments as irrelevant to determine whether the actions of the concerned persons resulted in statutory criminal liability. Furthermore, Krajišnik challenges Krajišnik challenges to the trial chamber's findings on the creation of Serb autonomous regions and districts, on the creation of the Bosnian Serb Assembly, and on the SDS instructions of 19 December 91, on the proclamation of the Bosnian Serb Republic, on the consolidation of Bosnian Serb legal authority, and on the support for arming activities are dismissed. The arguments, however, are irrelevant, undeveloped, unsupported, fail to address the remaining evidence the trial chamber relied on, or challenge factual findings on which the conviction does not rely. For similar reasons, the appeal chamber dismisses Krajišnik's challenges relating to the trial chamber's finding on the Bosnian Serb government and judiciary, the Bosnian Serb presidency, the armed force, the MUP, Minister of Internal Affairs, crisis staffs, war presidencies and war commissions, and Krajišnik's style of leadership. I will now turn to the supplementary challenges related to the issue of JCE made by JCE Council on behalf of Krajišnik. First, JCE Council challenged the legitimacy of JCE liability and contest the finding in the Tadic appeal judgment that JCE existed under customary international law. The appeal chamber considers, however, that JCE Council advanced no cogent reasons why it should depart from its holding that the statute provides, albeit not explicitly, for JCE as a form of criminal liability. This subground is thus dismissed. JCE Council further submits that the trial chamber erred in finding that JCE is a form of commission under Article 7.1 of the statute, rendering nugatory the other modes of liability. However, since the other forms of liability are distinguishable from JCE, the latter does not render the other forms of liability under Article 7.1 nugatory. This subground is also dismissed. Next, JCE Council submits that Krajišnik lacked the proper notice that he faced JCE liability, a concept that allegedly did not arise until 1999 and has expanded since then to include high-level officials with only tenuous connections to the crimes. The appeal chamber recalls, however, that when it interprets the JCE doctrine, it does not create new law. Instead, it merely identifies what the proper interpretation of that doctrine has always been, even though not previously expressed that way. This does not contravene the nullum crimen sine lege principle, and this subground is thus dismissed. JCE Council further asserts that Krajišnik's political speeches cannot, as a matter of law, constitute a contribution to the JCE because they were protected under his right to freedom of speech. The appeal chamber disagrees. What matters in terms of law is that an accused lends a significant contribution to the commission of the crimes involved in the JCE. Beyond that, the law does not foresee specific types of conduct which per se could not be considered a contribution to the common purpose. Hence, this part of the appeal is dismissed. Similarly, the appeal chamber rejects JCE Council's submission that the groups of 1,008 and 1,001 detainees from Maniace camp were not moved by JCE members, but rather under the supervision of the UNHCR. The fact that the displaced persons were accompanied by international forces did not render their displacement lawful. The appeal chamber accepts in part, however, JCE Council's supplementary arguments with respect to the identity of the rank and file JCE members, Krajišnik's responsibility for the expanded crimes, and the lack of findings on a link between the physical perpetrators and the JCE members for some of the original crimes. The remainder of the grounds of appeal raised by JCE Council is dismissed. The appeal chamber will now turn to the appeals of the sentence by amicus curiae, Krajišnik, and the prosecution. Amicus curiae argues that the penalty is excessive, given that Krajišnik did not directly perpetrate or order any of the crimes. He adds that the trial chamber wrongly considered the acts of others in calculating Krajišnik's sentence. The appeal chamber finds, however, that the fact that Krajišnik did not directly perpetrate or order any of the crimes does not necessarily entail that Krajišnik should be entitled to a lesser sentence. As to the allegation that the trial chamber referred to acts of others in calculating Krajišnik's sentence, his argument clearly fails. This ground of appeal is thus rejected.